The next case is People versus Urban. It's also a mini oral argument on the application. You each have 15 minutes. Mr. Van Hoek, you may reserve time.
Yes. May it please the court, Peter John Van Hoek on behalf of the defendant appellant, James Urban. I'd like to reserve just 1 minute of my time. And I'll waive the free fire, no questions.
Great, because I have a bunch of questions.
Okay, good. It's interesting in this case.
Oh, I thought you said you waived.
Excuse me? Oh, I'm sorry, I didn't really
I'm serious.
Okay. Go ahead.
Okay, here are my series of questions. This is a weird, Coy is a weird case. I mean, it's not about whether the underlying DNA evidence is admissible, correct?
No, that's not correct.
And that's not correct?
No.
Okay, go.
No. In Coy, which was my case, I was the attorney.
Oh, well, that's helpful.
Yeah.
Good.
In Coy, there were two pieces of evidence. There was sperm cells, and there was blood found in the apartment where the decedent was. The defendant admitted having sexual relations with the decedent a couple of days earlier. The question becomes then, whether the blood, the mixed quantity of blood that was found on the doorknob and a knife, any of that DNA was from the defendant, which made it much more incriminating as to the murder case. What happened in Urban was that the DNA expert that testified as to a statistical analysis of the likelihood that the sperm cells were Mr. Urban's DNA, but said because back then the science was different, less progressive than it is now, that the lab could not do a DNA analysis, a statistical analysis with a mixed sample because the blood came from two different donors.
We're talking about Coy now, not Urban.
Coy,
okay.
Yes. Yeah.
So you said
and what happened in that case was the prosecutor got up and testified and said, we proved it was Mr. Coy's blood just like we proved it was Mr. Coy's sperm cells.
So this was in the prosecution's argument?
Yes.
Right.
And the problem then was because of the fact that the prosecutor took the expert's testimony that the sperm cells matched Mr. Coy's DNA, and the blood was there and had two different donors, but couldn't say that, misled the jury into believing that each one were equally probative, the findings as to the sperm cells as to the blood. And that's why in Coy, the court said in the absence of an interpretation of that statement that we've proven that Mr. Coy was one of the donors of this blood was misleading to the jury. Okay. But that was the science back then. And that's why the court said, based upon a number of other cases from across the country when DNA evidence started to be admitted, was that you have to have something more than the expert coming in and saying there's a match. Because the word match doesn't mean anything to a juror without the comparison analysis, the interpretation analysis that Coy said was necessary for admissibility. Okay,
but back to let me go back to where I was going.
Yes.
I think I'm not as, you made me think I completely missed something, but I don't think I have. So Coy it was 2001 Coy was decided?
2000, yes.
2000. So, DNA was still sort of new, and obviously the techniques were not as advanced as they are today, correct?
Correct.
And in this case, there was no objection about whether the DNA evidence was admissible, correct? The objection is about how it was talked about to the jury. Is that right?
No. There was no objection to the admissibility of the testimony of Ms. Urca, who was the state police lab scientist.
Nobody said we want a Daubert hearing on whether the technique used in this case. By the way, what technique was used? Do you know?
Excuse me? I don't know because you didn't testify to it.
Okay, and the trial lawyer didn't object, and didn't ask for any Daubert hearing, didn't object under 702. There was no objection about whether the testing itself was admissible, correct?
No.
Okay.
Which is why in the alternative I was running ineffective assistance of counsel for trial counsel not to have known that Coy required testimony as to a statistical or analysis before that testimony was admissible. As the trial judge should have known, as the prosecutor could have known, as the defense counsel should have known, since Coy has been the standard, the published foundational standard of Michigan for 18 years.
Okay, but let me go back. I think Coy is a weird case because what it says is we require, trial courts require some kind of qualitative or quantitative, and we can talk about what that means exactly. I know that's a lot about what we're actually here for, and I'm asking you a bunch of other stuff, and I apologize, but you're here. You could have kept your retirement going, but you showed up, so. I'm
now technically retired as of 6 days ago.
Yeah, well, yeah, you got 10 more minutes. So.
Okay.
It's a weird case because can you think of any other example where appellate courts tell litigants how they should talk about or introduce evidence that has already been determined to be admissible? So there's no Daubert question, there's no 702 question, there's no, which there may well have been in this case. You may have a separate, I have no idea about any of that because you and I both don't know if it was star mix or true allele, some of the technologies that may well still be subject to a Daubert challenge. I don't know any of that, but it's not in the case.
No, it's not on the record.
But isn't it, think of any other kind of scientific evidence where an appellate court says, hey, litigants, you have to talk about your admissible evidence this way. Like, why would we do that? I can understand a party saying, hey, this didn't come in a way that was fair to me, so unfair that it violated my due process rights. Okay, then we have to think about that. But we don't tell parties how to present their otherwise admissible evidence, do we? Why is COI
Oh, we do all the time.
What, like how?
Because
give me another example.
COI is a question of a foundation that has to be established for the admissibility of evidence. This court, all through the court rules, there's standards of who can be an expert. There's all sorts of standards across the law, both statutorily and evidentiary, of a foundational standard that you have to meet before you can admit evidence. And that's all COI is all about.
You really do think COI is like a shortcut for Daubert in DNA, and so whenever DNA evidence whenever a party requests to admit DNA evidence, which could come from either party, of course,
yes,
they have to jump through the COI shortcut instead of the Daubert 702 process?
Well, I mean, Daubert and 702 are different foundational standards. There may be some objection under Daubert as to a particular type of scientific testing that's totally separate from this. And
so your
702 qualifications of the experts might be different. But this is a situation, I think, and COI's not a standalone case across the country. COI relied on a bunch of other states, which I've cited in my brief, that have the same ruling.
Back in 2000, when everyone was kind of afraid of DNA and they didn't know what to do with it.
There's still new states now, and it's still a standard across the country. Because even with DNA progressing, DNA, like most science, is not static. And we've all seen how DNA testing has changed in this 18 years. It's much more complicated. It's much more specific now.
And the objections about star mix and true allele, that there's some kind of black box algorithm that does it and defendants don't have a right to. I understand there are really important Daubert 702 questions with respect to that science.
Sure.
Those aren't in this. No one has objected to the science that underlied the DNA in this case, right?
No, I don't think there's an objection to the science of statistical analysis. And I'm not claiming that was the situation here. I think what COI is all about, and what the other cases are all about, is a recognition that DNA evidence is both incredibly complicated and far beyond the ability for lay jurors to really understand, and can be incredibly probative. And in that situation, when an expert gets up there and says, I tested this known sample from the defendant or from somebody else versus this sample we found at the scene, and that's a match, what does that mean? And the COI court, a lot of other people said, you have to explain, because it's so complicated, because the term match really doesn't have a lot of meaning, beyond the expert just saying, hey, I'm the expert, I said it's a match, that you have to explain to jurors through a quantitative or qualitative analysis what that really means.
But what if a defendant says, I would rather not have the expert say there's a 1 in a quadrillion, bajillion, dajillion chance that it wasn't me. I would rather the expert say the meaningless phrase to a reasonable degree of scientific certainty, a phrase we know means nothing in science or law. That sounds better to me. I might have a better chance at
Well, it's not up to the defendant to make that determination. The proponent of the evidence has to meet the foundational standards. I'm a defense counsel. If a prosecution presents a DNA expert and they're trying to prove my client committed a crime, and the expert comes up and says it's a 1 in 5 quintillion chance that it was somebody other than the defendant, I'm not too happy about it, but I can't object to that on the basis that it's probative and incriminating. But I can require that the expert, under COI, require that the expert not only says...
But you'd be a really bad lawyer if you did that. That's the problem, right? Wouldn't you be a really bad lawyer if you required the prosecution's expert to say there's a 1 in 5 gajillion chance?
It's not a question for the lawyer. It's a question for the courts. It's a question for the judge to say, before we can allow an expert to testify as to a DNA match, the expert must also explain what match means through a quantitative or qualitative comparison analysis. Because jurors don't understand what the term match means, because those numbers are not in every case of DNA evidence do you get these gigantic numbers. So jurors who watch TV and hear about DNA and think about it what it means, an expert stands up and says, there's a DNA match. Most lay jurors are going to think that's 100% sure.
So the danger of that you're seeking to prevent is not perhaps necessarily in this case, but in cases where there isn't 1 in 18 zeros chance.
Absolutely. In every case, I'll give you an example. Just by coincidence, yesterday, I said I'm retired, but I'm still handling some cases. Yesterday, taking time off from preparing today, I was reading transcript of a murder case. And there's a DNA expert, an expert from the state police. Excuse me?
This is what you do on your retirement?
Well,
Fair enough.
I'm not getting paid anymore, but I'm still working.
Fair enough.
There's an expert testifying, and they were trying to prove they had a weapon that was allegedly a murder weapon, and they swabbed the trigger handle of this weapon. It was found in an abandoned house, and the DNA expert came in and said there were 4 donors of DNA to this that we found on the swab. And they asked, and they did the statistical analysis all the way through. They asked the expert, what does that mean? What did you test it in comparison to the known sample of the defendant? And the expert said, yes, there was a 2.9 times chance that it was more chance that it was the defendant plus 3 other unknown people than 4 unknown people. And said, and under our standards, anything under 100 is what we call uninformative. And I'll read you, I've got the transcript. Defense counsel stood up and said, if it's uninformative, why are you even talking about it? Here's the answer from the expert. Because it's required by the quality assurance standards set forth by the FBI. So I cannot come into court or issue a report saying there is support either for one hypothesis saying their DNA is there or not there without putting a likelihood or ratio or statistics to it. If I do not put that number associated with it, our lab wouldn't exist. That's what these labs do. The statistical analysis, the statistical stuff that we see all the time, that's the gold standard right now under existing science. They all do it. It's not burdensome. I presume they have software that does it. It's not very expensive. There's been no claim made in this case or any case I've seen that this is something that's going to be difficult to meet. In fact, since COI, it happens all the time. We've all read it. We all see it all the time. This is what they do. This is why they developed the database of the different demographic populations to make these comparisons. Because without those comparisons, the question of whether it's a match doesn't mean anything.
But usually the courts let parties figure out how confused or not confused they want juries to be. There's lots of other specialized science that comes into trial courtrooms, and
Yes.
we don't micromanage how the lawyers have to talk about it, right?
We're not talking about how the lawyers have to talk about it. We're talking about a foundational requirement for an expert to be able to come in and testify as to a purported DNA match.
Counsel, I'm confused about things. You'll have to help me a little
Sure.
bit. You're saying that it is not enough to summarize the DNA analysis by the reasonable degree of scientific certainty language. There has to be some foundational qualitative or quantitative evidence.
Yes.
Then you're saying there doesn't necessarily have to be quantitative evidence, and indeed, as the Chief Justice indicated, one can easily understand circumstances in which the universe of defendants might not want that additional clarity. So that leaves the qualitative evidence.
Yes.
What is an adequate supplemental expression of qualitative evidence that would suffice? What does the trial court have to do where he hears the expert talking about a reasonable degree of scientific certainty? How is that properly qualitatively embellished? What would be an adequate that is, or in other words, phraseology that would give greater meaning to that?
Well, it's difficult for me to answer that because I'm not a microbiologist. I think the situation, I think
Without
when COI,
micromanaging, as the Chief Justice
Well-
also indicated, is problematic when you're talking about expert testimony.
yes, but I think when COI said that, I think when the court in Coy said there has to be some qualitative or quantitative analysis, they said it specifically that way rather than just say you have to have statistical analysis. But all the cases that they relied on that cited that they were talking about statistical analysis as that a requirement. And that, I think, was what Coy was talking about. But I think when they said that, when they used that phrase, some qualitative or quantitative analysis, they did that specifically because they didn't want to hamstring a requirement that could change as science changed. In the future, we may have a qualitative rather than quantitative analysis, which is better, more probative, more accurate, more meaningful to a juror, but who knows? That's up for the science. None of us will understand what DNA science is going to be 10 minutes from now versus 10 years from now.
So as to avoid every DNA match case from coming to this court in the appellate process, give me some general guidance that we can incorporate in an opinion that we might choose to write that would help give meaning and force to your qualitative analysis language.
Well, I would think that at this point in time, as far as I know, and as far as the experience I've had in looking at these cases and looking at everything else, again, the gold standard of this sort of comparison analysis is the statistics, because that's what they were developed to do. At some point in the future, there may be a qualitative, not quantitative analysis, which supersedes that within the scientific community. Another Dober or something like that, it could be found. That now is the gold standard. But I don't think any of us can say what that's going to be. But right now, without this, I don't know if there's any sort of a different analysis they do, but it seems to me that if the FBI requires it and the state police require it and people across the country do it, that this statistical interpretation is the standard that everyone accepts as being both reliable and necessary. And that's all Coy is saying. Don't let an expert just say match without explaining what match means. And because it's so complicated, and it's much more complicated to a jurors than when a fingerprint expert comes up and puts up two pictures and says, look, you can see, the different points on the fingerprints that match up. And we all know fingerprint analysis is not perfect either. But something as complicated as DNA, way beyond the ability of lay jurors to understand, they need something more than just an expert saying, believe me, I'm the expert, this is a match.
Can that something more ever be exclusively qualitative?
It may be, but that may be something for science to determine.
You're not going to give us any hints as to what that might be.
Yeah. I'm not aware personally of any current scientific qualitative analysis procedure that equals or even approaches the believability and the sort of all-encompassing inclusion of this statistical analysis, because that's why they created this database. Why not?
The Chief Justice has indicated defendants as a class are now going to have the benefit of it being communicated to the jury that the likelihood of a DNA match here is a trillion, quadrillion, a nonillion to one, as opposed to simply this summary formation, right?
Well, again, if that's the evidence, it's not beneficial, but the defense counsels don't have any ability to, unless they can show that this expert did it wrong, they have no real ability to object to that. Just like you can't object to when a witness comes in and says, I saw the defendant shoot him. You can't stand up and say, well, that hurts my case, it must be inadmissible. It isn't.
Thank you, counsel.
Thank you.
Good morning. Brent Morton with Eaton High Prosecutor's Office. May it please the court. You should deny the application in this case for two major reasons. There is no record in the trial court where this was challenged. There's never been a challenge to the science or the reliability of these results. Even now, the challenge is that the interpretative information wasn't testified to or given to the jury in a quantitative, numeric fashion. Not that the results of the test aren't accurate. Secondly, there was no controversy in this case. Mr. Freeman Urban's trial attorney successfully used the inconclusive results on the handgun to argue and get acquittals on a felonious assault charge of a firearm and a felony firearm charge. Furthermore, he used, the theory of the defense was this was a brawl. It was a physical fight between the two of them and not as bad as the victim said. And he successfully used the DNA matching blood on the pillow that matched Mr. Urban to argue that he was also physically injured during this brawl And he was able to get a lesser inclusive charge of domestic violence instead of the aggravated domestic violence charge. So there's really no controversy here that you need to solve a problem. Coy is a good decision. It's lasted for 18 years, and no one's been before you asking to change the standard. It works and allows experts to be experts. In this case, the experts were experts. And at the time, Michigan State Police Lab, which was consistent with other labs across the country, and that information is found in Ms. Schelling's affidavit, starting in the appendix of 125B. The lab at that time said if the match probability was less than 1 in 7 trillion, which was the world population, then you're going to put this qualitative statement on the report. We're not going to put the numbers in because we want to be conservative. We want to be fair to defend it, believe it or not. And so that's what they did. They have stopped doing that. But at the time, there was a window of time where they did this, and other labs in the country did this. So there is a qualitative statement there, and the experts in the field determined that that was an appropriate qualitative statement. And I think it's inappropriate for this court to micromanage and say it has to be numeric, it has to be this, particularly in area of science, as was alluded to earlier, is so changing so quickly. Now to go to Chief Justice McCormick's question, you asked Mr. Van Hoek what method was used. In the appendix 59A to 61A is the lab report from the lab. And it indicates the DNA testing was done using the polymerase chain reaction and the PowerPlex fusion system. So those were the tests used to do the DNA. Now, I think that in Mr. Van Hoek's defense, I think he was probably referring to the science behind the statistics or the probability matching. The matching that was done and wasn't testified to but was done by the lab analysts at the time is outlined as part of the Ms. Schelling's affidavit, and also the calculations are there, and an article at 132B discusses the science behind the probability match, or the articulation of the probability match. I'm not going to delve into that. I don't understand it. But I'm happy to answer other questions, and there's probably a couple other points I want to make along the way.
Well, I'm a little befuddled by your position as I am by opposing counsel. What do you mean precisely by your argument that there are reasons against using numerical results? Name one such reason. Is it that juries just don't understand astronomical-like numbers?
I think, as a prosecutor, I took an oath to be fair to everyone and seek justice. I think there are times where the numbers are so overwhelming that they can sway a jury without having substance. For example, in the Coy decision, they refer to the evaluation of forensic DNA evidence. It's a paper from the National Academy Press. It's Coy on footnote 13, and it's included in the appendix as 2B. There they talked about, even if there's probability, there's still human error in conducting the test. And there was a concern at the time, and I think the concern is still valid, that there could be human error, and the probability numbers could eclipse that and make it look as though there's no way that this is infallible.
That's always possible. I mean, there's human error, and we've seen it in DNA labs around the country. Human error happens, and presumably parties have a way to figure that out in Daubert hearings and 702 hearings and in cross-examination. But I guess I'm also confused. Why wouldn't a prosecutor introduce, obviously if you knew of human error in the lab, you'd have an obligation to make that information available to the defendant so they could investigate that and challenge it. How does that answer Justice Markman's question? If you have quantitative evidence that helps your case, why wouldn't you introduce it? Well,
For example, in this case, there was no challenge to the reliability of the match.
Yeah.
It was used by the defense. Now, as a prosecutor,
so that's one answer. It might not. It might have seemed beside the point in this case. You didn't think it was important to establish to nail the point that it was definitely the defendant's DNA. Is that what you're saying?
Right, well,
It's a different kind of case.
going into that statistical testimony can be confusing to the jury and can sidetrack the pace of a trial for an hour easily. You know,
Okay,
if
so there
there's
might be a
questions.
strategic reason even on your side where you don't want to waste time on that. That's a good answer. I get it.
I want my lab person off. I want my
Right.
victim off at this time. My victim's only available this day. I only have so many days to do the trial. I don't want to drag it over. And when it's not a controversy, then you're in a situation where you don't have to explain to the jury, well, you really need to rely on this. Because that opens the door for the defense attorney to say, we spent hours talking about numbers. I'm confused. You know, so I think that there's statistical reasons for both parties to say, no, we're good. We all agree this is a match. And that was the case here.
Can you help me with how I'm thinking about the rule from Coy? I mean, you both agree it's a good rule. No one's asked us to upset it, so this is probably academic, right? But I understood that Coy was a sort of a judicial overlay on how this particular kind of scientific evidence, once it's deemed admissible, should be talked about to a jury. And it gave this framework of qualitative or quantitative. And I have to agree with Justice Markman. I don't know what qualitative means exactly in the course of DNA. Nobody seems to. But that's what Coy did. Am I wrong about that? Or do you agree with Mr. Van Hoek that instead Coy is kind of an extra admissibility step, that in fact with DNA evidence, it's not admissible unless it satisfies Daubert, 702, and also Coy? How do I think about Coy?
The way I read Coy, for what it's worth, I think that you have the admissibility portion of it where the testing is done, that it has to be legitimate or sound science. The next step is, in order for that to mean something to the jury, there must be some interpretation or explanation, I guess would be a way to put it, to the jury that this is what a match really means.
So
because a match isn't necessarily 100%. There could be identity.
It's rules for how to present otherwise admissible evidence. That's what you think of it as.
Yes, and if
you're fine with it. You think it's a fine rule.
Yes, because with the qualitative and quantitative opening requirement,
It's
it
broad
allows the
enough that-
experts to be experts, and all the experts to tell us what it is.
Thank you.
To follow up on that point,
Can
though,
I ask a question? Originally, the Court of Appeals opinion was unpublished in this case, correct? And the prosecution moved for publication, I believe, saying that it provides an important clarification of the admissibility of DNA evidence under Coy.
yes, I asked for that.
Okay,
publication.
so while, you know, there's no challenge to reliability, it's sort of, I was sort of taking your argument as, you know, this isn't really anything to see in this particular case. Why was it published, and what is the effect of, or why did you move for publication? What does this particular case add to the Coy standard that merits publication of the Court of Appeals opinion?
Well, why I asked for it to be published is and with all due respect to the retired Mr. Van Hoek, who doesn't retire, no. He argued that the qualitative statement wasn't appropriate. At oral arguments, he argued that it needed to be numeric. And so I asked the court to publish the decision because Coy doesn't say it has to be a numeric, it doesn't have to be a quantitative numeric figure in order to communicate that to the jury. It can be qualitative as well. And so that's what I asked them to publish it on, is just to clarify that, look, you can't stand up and argue, well, this wasn't in a ratio format, so it's not acceptable. And I asked the court to publish it to support the decision in Coy.
So Coy already says it can be words or it can be numbers.
Yes, it says
right?
qualitative or quantitative
And this
analysis.
says it can be words. This clarifies or reemphasizes that it can be numbers or words. Words are okay, and these particular words, within a reasonable degree of scientific certainty, satisfy Coy's qualitative standard.
Yes.
Okay.
If I may, I want to return to Chief Justice McCormick's, the point we were making. And I just want to point out to the court that the probability match back when Coy was done, because Coy was remanded, there was another trial, and there was a second decision. In the second trial, they did probability matching, and they did numeric matching. And the second decision was the second appeal decision was 258 Mishap 1 in 2003. And those numbers were, for the Caucasian population, 1 in 952. Now the numbers are for for the victim, 1 in 10.33 nonillion for the Caucasian population, and for the blood that was on the pillowcase for Mr. Urban, 1 in 18.62 nonillion for the Caucasian population. So we have much rarer, we have more precise interpretative results now than we had then. Both are reliable, but I think that to try to narrow it down at this point as the science and the interpretive science changes is improper.
Thank you, counsel.
Thank you.
Mr. Morton, in capital punishment states, not of course including Michigan, one often hears the argument made that capital punishment is a different punishment because of its irrevocability. And as a result of its unusual character, there has to be particularly strong precautions. And essentially what's been characterized as super due process has to be accorded prior to imposing that kind of sanction. Here we've got DNA evidence, which is arguably different too by its utterly damning and compelling character. Isn't that a good argument for having some kind of policy that provides for kind of super clear and super cautious accompanying instructions when you have DNA evidence being invoked in the courtroom? Isn't there kind of an analogous sort of relationship there? This is something different than the ordinary kind of evidence you usually see in the course of the criminal justice process, isn't it?
I think COI gives us a higher level because it says, look, you not only have to get it in scientifically, you have to explain to the jury what it means. But I do caution the court from going down that road because science, when it first comes out, is always awe-inspiring and always overwhelming and always, negative for horribly negative for the defendant. But as it goes on, it evolves and it changes. And I think we've seen that in DNA. DNA is now used to exonerate people. It's used to convict in cold cases. Heck, people send it out to find out where their ancestors came from. We put it in the mail and send it off. It's commonly used now, and I think it's better understood than it was 20 years ago. So but I don't think the COI should be narrowed. I think it's a smart decision that allows the court rules to evolve along with the science. But I respect that DNA is still very strong evidence. It's very important evidence. But I think if you go down the road of compartmentalizing evidence, you create more problems for jurisprudence as a whole.
Thank you, counsel.
Thank you very much.
Case will be submitted. We didn't let you save your minute. Sorry, Mr. Van Hook.